Ways through which we said you can become a member. So as I've told you, a member of a company is a person whose name actually appears on the register of members. What is a register of members? Simply an enlisting of all the members of a company. So how will you find your name actually being enlisted here? So I've told you the methods of how you can become, or ways of how you can become a member is any way basically that can actually lead you to basically acquire or get shares of the company. So in this case, we said, for example, if the shares are actually allotted, so you can become a member of a company through number one, allotment of shares. So allotment of shares. So that is one of the ways of actually becoming a member of a company. What do you mean by allotment of shares? For example, today, if Safaricom basically invites people to buy its shares, then you apply for the shares. The shares basically will likely be allotted to you. So once you allotted the shares, you become a shareholder in that company known as Safaricom. And of course, your name will likely be included in the register of members. So number one, through allotment of shares. Number two, through what we call transmission of shares. So there's that one which I told you appears in both of them, whereby it also basically leads you to losing membership and also gaining membership. Transmission is actually one of them. And of course, under transmission, we simply mean death, bankruptcy, or insanity. So in this case, the shares will likely be transmitted. So for example, if someone had shares in a company and of course he passes on, so the shares basically will go to the beneficiary. So you can see in this case now the beneficiary is becoming a member of a company as a result of death. Bankruptcy, the shares will likely go to a receiver. Insanity, they can go to a trustee or any other beneficiary that has been stated in such a case. So transmission of shares is actually also one of the ways of how you can become a member of a company. So I've told you how it happens. So if a person is a holder of shares in a company, in this case, it simply means that he's actually a member. So if the person actually passes on, or basically is declared to be bankrupt, the shares will be lost to another party. So that is a beneficiary. Now, in this case, the beneficiary becomes a member through what we call transmission of shares. So number one, allotment of shares. Number two, transmission of shares. Number three, that actually also appears, transfer. So transfer appears in cessation and also appears on how you become a member. So when you transfer shares, you basically, it simply means that the shares have been transferred from one party known as a transferor to another party known as a transferee through an agreement or a contract. So if they're actually able to agree, the transferor can be able to transfer the shares to the transferee. In this case, now the transferee becomes a member through transfer of shares, while the transferor loses membership, So we've said number one, allotment of shares. Number two, transmission of shares. Number three, transfer of shares. Number four, by subscribing to the memorandum of association on the formation of the company. So in that case, it simply means you actually agree to be one of the founding members of the company. So when the company is being registered at the registrar's office, so your name will likely basically be included there as one of the subscribers of the shares of the company on the formation of the company. So you subscribe to the memorandum as to how much you've actually basically acquired or gotten as shares on the formation of the company. So number four, subscribing to the MOA of the company on formation of the company. Number five, by taking up what we call qualification shares, so you'll likely also become a member of a company by taking up qualification shares. I think I explained what are actually qualification shares. In this case, you are saying, if you can be able to recall very well, we said that when Ebi will become a director at Safaricom, Ebi will be called upon to take up some shares at Safaricom. So these shares that will be taken up by Ebi will be known as qualification shares. So it is actually one of the requirements, one of the qualifications of becoming a director in a company. So when Ebi will become a director at Safaricom, Ebi will be called upon to take up some shares. And of course, we said financial prudence requires that when you become a director in a company, you become a part owner. So Ebi will be required upon to become a part owner, and therefore in this case, she will take up qualification shares. And in this case now, since she has the shares, she has acquired the shares, it simply means that now her name will likely be included in the register of members. So taking up qualification shares is actually one of the ways of how you can actually become a member of a company. And then the last one is through what we call the doctrine of estoppel. So in this case, we said, for example, if your name appears in the register of members by mistake, so you can't actually deny that you are not a member of the company. So for example, in this case, if you have gone ahead, for example, to participate in the activities of the company, yet your name appears in the register of members by mistake. So during that particular period, you participated, for example, in attending to meetings or doing anything to do with the company, it simply means that you can't deny you are not actually a member of a company. You are not a member of a company. So that is how you can actually be able to become a member of a company. So we've said allotment of shares, transfer, and transmission. Those two actually appear in both of them. Cessation and also how you become a member. And then I've told you subscribing to the memorandum of association. And then we also say that when AB will take up qualification shares. So if you take up qualification shares in a company, you'll become a member of the company. And then, of course, the last one, through the doctrine of estoppel. If your name appears in the register of members by mistake, you cannot deny that during that particular period whereby you participated as a member, when your name was actually appearing by mistake, that you are not a member of the company. Through the doctrine of estoppel. Through the doctrine of estoppel. Through the doctrine of estoppel. Estoppel. Through the doctrine of estoppel. Through the doctrine of estoppel. Ensure when you join the meeting, you mute yourself. So just mute yourself. So there's that Roman 2, outline 4 rights of a member in relation to meetings of a company. So 4 rights of a member in relation to meetings of a company. So 4 rights of a member in relation to meetings of a company. So 4 rights of a member in relation to meetings of a company. So we have right to notices of meetings. So you as a member of a company, you have a right to get notices of all the meetings of the company, notices to all the meetings of the company. So you have a right to the notices of meetings of the company, right to attend the meetings. So you can't be denied the right to attend the meetings, right to respond or contribute to any matter at a meeting of a company, right to appoint a proxy, right to vote at meetings, right to vote at meetings. So you have those rights. You can be able to vote at meetings, right to appoint a proxy. You know, is actually a proxy. So if you can remember about meetings, we say that when the company is sending out a notice for meetings, they'll attach a form for you to be able to appoint a person to be able to represent you. For example, if you're not actually able to attend to the meeting. So you have a right to appoint a proxy in case of a meeting, right to appoint a proxy in case of a meeting. Then right to vote at meetings. So these are the rights that are quite obvious when you're a member of a company, you'll be entitled to them with regard to. Remember that question is talking about meetings. So as you mentioned, the rights put in your mind, meetings. What are the rights of you as a member with regard to meetings? So sometimes they could just generalize and say, what are the rights of a member of a company? So now those ones you can be able to, you can mention a lot of them, several of them. So So if they are not actually basically specified meetings. So right to notices, right to dividends, right to attend meetings. So you can be able to mention several of them. So right to inspect registers. So there'll be several of them that you can actually be able to mention with regard to rights of a member of our companies. But this case, they are basically specified meetings. So you must be able to underline that particular term, meetings. So with regard to meetings, those are some of the rights that you can be able to enjoy as a member of a company, So we've said here, under this particular topic, we learned about membership of a company. We learned about register of members. So there could be a simple question: what are the contents of a register of members? Or they could ask, in this case, what are the requirements of a register of members? So just the same question. What are the requirements of a register of members? What are the contents of a register of members? So what are the contents of a register of members? So briefly, I've already told you, it enlists all the members of the company. So if they ask for the contents of what is normally contained there, they could put there probably like, let's say, for example, 4 marks. So number one, what you put is the name and address of a member of a company. It will be there. Name and address of a member of a company. It will be there. Name and address of a member of a company will actually be there. It will actually also contain the dates when that particular person actually became a member, and the date of that particular person actually became a member. Also, number 3, what will be there is the date of cessation of membership. Date of cessation of membership will actually be there. Then probably if you are a member of the company and you have some shares, it will indicate besides your name, the number of shares allocated to you as a member of the company. So you're saying number 1, name and address. It enlists just the members of the company. So what are the contents? Name and address of a member of a company, date when he or she joined as a member of a company. Number 3, date of cessation of membership of a company. And then number 4, what you can confidently say, you can be able to say the number of shares held by that particular member of the company. So that basically will be the contents of the register of members of a company. Register of members of a company. Register of members of a company. Most importantly, also we learned about this particular rule. It is known as the rule in force versus habitual and its exceptions. So we also learned about that one, but sometimes we call it the majority rule. So it has actually also exceptions. So under this particular rule, if you can be able to remember very well, we said that under this particular rule, it states. What does it state? It states, so this rule known as the majority rule or rule in force versus habitual, it is under membership of a company. This rule states, that no person, so Agnes, ensure you have muted yourself. So I can see today, Juliet has muted herself. So we are saying that this particular rule actually states that no person can bring an action on behalf of the company, but it is only the company itself by acting upon a decision that has basically already been decided upon or basically made by the majority of the members of the company. So just from the word itself, the majority. So the majority basically will have their way, while the minority will have their say in a company. So it is normally actually applied in several scenarios that the majority will basically have their way, the minority basically will have their say. It states that no person can bring an action on behalf of the company, but it is only the company itself by acting upon a decision approved by the majority of the members of the company. So this particular rule actually recognizes the principle of separate legal entity. So you haven't gotten it. I'm saying this rule states no person, hakuna mtu anaweza leta kesi on behalf of the company kwa koti, but niyo kampuni yenyewe kwa sababu it is a person by itself. it can be able to sue or be sued in its own name. No person can bring an action in a court of law on behalf of the company, but it is only the company itself by acting on a decision that has basically already been approved by the majority of the members at a meeting of the company. So therefore, in this case, what I'm trying to say is that, for example, if a company is to bring an action simply means that you bring a case or maybe an action in a court of law accusing someone else. It can only be the company itself in its own name by acting on a decision that has already been approved by the majority of the members of the company. So if the company is to sue, the members have to meet in a meeting and actually agree there's a wrong that has been done to the company. So therefore, the company can be able to sue in its own name. So you can be able to see it recognizes that a company is always a separate legal entity. It is a person on its own, and therefore it can be able to sue or be sued. It can be able to sue or be sued. So that is what this particular rule actually states. And therefore, most importantly, the best advantage out of it, it recognizes the principle of separate legal entity, that a company is a person on its own from the owners. It can actually basically be able to sue or be sued in its own name. So that is one of the advantages of this particular rule known as the majority rule. So that is basically what it says and what it actually means. So in this case, it normally have some exceptions. So it doesn't actually prevail always. So it can have certain exceptions. It usually has some exceptions. So the exceptions to the rule in this particular rule in force versus habitual, in force versus habitual. So exceptions. So number one, decisions requiring number two, if the majority members have acted, ultra vires, number three, in case of oppression, of the minority members of the company. Then number four, what you can be able also to mention, in case of violation of membership rights, in case of violation of membership rights, in case of violation of membership rights, then in case of violation of membership rights, then the last one you can be able to mention, in case of mismanagement of the company, in case of mismanagement of the affairs of the company. In case of mismanagement of the affairs of the company. So you can be able to see, so you're saying that the majority, so basically if they do any of this, so if there's a decision requiring a special resolution, that is we said at least 75% of the members to be able to approve. So you can be able to see 60%, it is still a majority, but in case that decision requires a special resolution, this majority is not actually enough. So it is not, that rule is not prevailing in that particular circumstance. For example, if it is liquidation of the company, which requires a special resolution, it simply means that even if 60% actually approve, it is still majority. It is still majority, but you can be able to see it can't approve such kind of a decision. So you can see the rule does not prevail there. So 60% is still majority, but they can't approve. They can't approve. So those decisions that actually basically require a special resolution, So if the majority members have acted ultra vires, what do you mean by ultra vires? Acting beyond or basically outside the requirements of the articles of association or memorandum of association. So I've sung this a lot of times. An articles is simply a document containing the rules governing the internal affairs of the company. It is like the constitution of the company. So if you act outside that constitution, you've acted ultra vires or beyond. So if this decision by the majority, it is actually basically beyond the constitution of the company, and then in such a case, that rule by the majority won't prevail. So it doesn't actually prevail in such a situation. In case of oppression of the minority members of the company, so for example, if this particular decision that is being made by the majority, it is simply basically to frustrate or actually oppress the minority members. So in such a case, they can be able to go to the courts and stop that decision by the majority. So minority are those ones basically who have minimal or basically small number of shares in the company. So wale wanyonge, so the minority members. So the majority can be able to gang up and come up with decisions that are likely not to be very favorable to them, just to oppress them. So they can be able to basically stop that particular decision of the majority by simply going to the court. In case of violation of membership rights, so when basically you become a member of a company, you'll be entitled to certain rights. So if these majority members have ganged up to basically violate those members, so that decision by the majority won't actually also prevail. So in case of mismanagement of the affairs of the company, so the majority are simply ganging up basically to come up maybe with business activities which are not favorable to the company or loss-making to the company. So you cannot allow the majority to continue to do such. So you can't allow them to continue to do such. So in case of mismanagement of the affairs of the company, that is actually also an exception. This particular rule won't actually also prevail. It won't actually also prevail. So that is basically what we mean by the majority rule or the rule in force versus habitus. So it is actually one of the major rules under company law, and of course it has its exceptions. So you can't afford to walk into an exam room without having a clue of what is actually the majority rule. That is the majority rule or the rule in force versus habitus. The rule in force versus habitus. So that is what you need to be able to know about the majority rule. So there is this one, derivative action and representative action. So if you check your notes very well, so representative action, I've already explained what is an action. So when you bring a case before the court of law. So what do you mean by representative action? Just to represent, just from the word to represent. It is where a member of a company actually brings an action in a court of law on behalf of the other members of the company. So in this case, what actually happens, the members of the company can be able to appoint one of them to be able to bring an action. Therefore, they contribute resources to that particular one member, then he brings the action on behalf of all of them. So he simply acts or actually represents them. So that's what we mean by representative action. Derivative action, it is whereby now a person decides, or basically a member of a company decides to bring an action on behalf of the company, So it is known as a derivative action. Remember, representative, it is on behalf of the members of the company. That action before the court of law, representative action. It is actually on behalf of the other members of the company. It is advantageous because they can be able to contribute resources and simply appoint one person to act on behalf of all of them, by bringing the action in a court of law. Derivative. Now this one is not basically representing the other members of the company. It is now basically whereby you as a member of a company, you decide to bring an action to remedy any wrong done to the company, So on the flip side or on the other side, I've told you under the majority rule that you cannot bring an action on behalf of the company, but it is only the company itself by acting on a decision decided upon by the majority of the members of the company. But under derivative, what is the teacher saying? You can be able to bring the action. Under what circumstances? Under the exceptions. then you can bring the action on behalf of the company to remedy any wrong done to the company. So because you are saying the majority rule does not prevail always, it has exceptions. Under the exceptions now, a member of a company or a person can be able to bring an action to remedy any wrong done to the company. That action brought before the court of law, it is known as a derivative action. And you can only be able to do it under the exceptions, because you can be able to see what the rule says. You cannot bring the action. But on the other side, the teacher is saying under derivative action, you can bring under what circumstances? Under the exceptions. You can bring an action to remedy any wrong done to the company. That particular action, it is known as a derivative action. So don't say that derivative action is Greek when you see it in the exam paper. So it's something you have an idea now. What is a derivative action? 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 So I want us to look at another past paper question. So that is all about membership. So that is all about membership. 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 So I think we've been able to revise that topic, membership. So I want us to look at this question. It is just from the same sitting. It is just from the same sitting, but now it's question number 7B. November 2019, question number 7B. So hope you can be able to see it. So question number 7B there, you can be able to see it. It says, summarize 4 strategies that a company might employ against hostile takeovers. So that particular question is from corporate restructuring. Corporate restructuring. So I think we've learned about corporate restructuring, and I think we learned about those particular techniques. I think it's the last thing you'd be able to see in your notes if you check on that particular topic about how a company can actually be able to avoid a hostile takeover. So we said some of the ways or strategies include, for example, number 1, what you can be able to do as a company. So I can just mention them here. How to avoid a hostile takeover. What do you mean by a hostile takeover? It is hostile, just from the word hostile. It is not very friendly. It is whereby, for example, in this case, a company like Safaricom decides to sweep the industry by simply acquiring all the players in that industry. So they don't want any competitor. So that is not actually a friendly takeover. It is very hostile. So they want to dominate that market and become like a monopoly. So the strategies they are basically employing to be able to acquire that other firm like Airtel or maybe Telcom, it is not in a friendly way. So they want to basically frustrate them or basically dominate them so that they can be able to maybe acquire them very easily. So since they are very desperate, they'll be able to acquire them. So if they use such kind of strategies or techniques, then we say they are using what we call they are doing what we call a hostile takeover. They are doing what we call a hostile takeover. They are doing what we call a hostile takeover. So in this case, what Airtel or Telecom can be able to do to avoid that particular hostile takeover. So number one, what they'll do, they can agree to be taken over by a more friendly firm, Then what also they can be able to do is to amend the articles for takeovers to be approved by a special resolution. You can just say by a special resolution. So that is 75% and above of membership, right? Special to be approved by a special resolution. Then another thing they can be able to do is give out hefty send-off packages, send-off packages to its employees. So give out hefty send-off packages to its employees. Then also what they can be able to do is borrowing to shy away the predator firm. They can also be able to do what we call counter offering. They can do a counter offer. So wanaweza jichocha pia au pia wanaweza nunua Safaricom. Wanaweza jichocha by doing a counter offer. So they give a counter offer. So they'll also use that particular strategy. Also, what they can be able to do, so apart from a counter offer, so we've said agree to be taken over by a more friendly firm, amend the articles for takeovers to be approved by the special resolution, give out hefty send-off packages to its employees, borrowing to shy away the predator firm, doing a counter offer involving regulators, and state why the takeover should not happen, should not happen. So therefore, in this case, they can be able to involve the competition authority. They can involve the capital market. So the regulators in terms of acquisitions and takeovers, so that they can be able to bring their case forth that if the takeover actually happens, it will basically maybe lead to a monopoly. So they can argue like that. So they can use that particular strategy to avoid a hostile takeover, So that is basically how a firm can actually be able to avoid being taken up in a hostile way. So those are some of the strategies that can be deployed by a firm to avoid a hostile takeover. So it is from the topic of corporate restructuring. So under corporate restructuring, we learned about what is corporate restructuring, what is corporate restructuring, what is corporate restructuring. We looked at the advantages or reasons for corporate restructuring. We also looked at so the types of corporate restructuring, So under this one, the major ones we looked at was schemes of arrangements, and compromises, There is actually also what we learned about is mergers. Then also we learned about takeovers and acquisitions. But of course, I told you there are several other ways of how corporate restructuring can actually happen. So we mentioned something about reverse merger. So we mentioned something about joint ventures. We mentioned something about share capital reduction. We also mentioned something about demergers. Joint ventures, reverse merger, share capital reduction, demergers. So those are some of the other ways of how a company can actually be able to restructure. So on the advantages or reasons, I think we mentioned that we said that companies would maybe restructure to cut on costs. So cutting on costs is actually one of the major reasons as to why companies restructure. Another reason it could be maybe they want to be very competitive or remain competitive in a particular industry. So if a company wants to remain competitive, they can be able to look for ways of how they can be able to restructure. For example, in this case, if they have maybe several branches, so they can cut on them and remain with fewer branches and maybe utilize the resources they have in terms of concentrating on those particular specific branches or the smaller number of specific branches. So cutting on costs, remaining competitive, can also be able to talk about utilizing the human resource properly, maybe the talent they have in the company appropriately. So that is actually another reason as to why companies can be able to restructure. So we said when you talk about restructuring, it's just basically changing the form or way through which this a company can actually be able to carry on its business activities. So it can go for internal options or basically going for external means of how they can be able to restructure. So those are some of the advantages or reasons as to why companies will decide to restructure. So you talked about cutting on costs, remaining competitive, utilizing the talent they have or human resource appropriately, or maybe doing away, number 4, you can talk about doing away with product lines which are not actually performing within the company. So that basically reminds me of this as another way of restructuring. So it's not a divestiture. So these ones I think I actually explained. So when I talked about a reverse merger, I emphasized that reverse merger is not actually the opposite of merger. So the opposite of merger is actually demergers. But for reverse merger, we said it is simply where a private company decides to go public by simply the shareholders of that private company acquiring ownership in a shell public company. So a public company that is not actually very actively maybe carrying on business. So they simply acquire. So Brian, you can mute yourself. So reverse merger, as I told you, what you mean by reverse merger? It is where shareholders in a private company, so you know what is a private company? So shareholders in a private company decides to basically trade as a public company by simply acquiring ownership or stake in an already existing shell public company. So they decide to basically convert their business interest in terms of from being a private company to a public company by already acquiring an already existing public company that has already been registered. And now they start trading or basically carrying out business activities as a public company. If they do such, we say they have done what we call reverse merger. So we say it is advantageous because in this case, they won't go into the cost involved in terms of, for example, doing an initial public offer or basically floating the shares of that company so that people can be able to acquire it to become a public company. It will likely be very easy for them in terms of saving on costs, and also it will save on time. It saves actually also on time of having to prepare prospectus and all the costs involved in preparing our prospectus. So it saves on time. So that is an advantage of doing a reverse merger. Number two, actually also it saves on costs. It saves on costs. So this question has been tested, so I can't recall the past paper. It is there. Define a reverse merger. What are the advantages of a reverse merger? So you can't afford to not be knowing about a reverse merger. So you're saying it is simply where shareholders in a private company decide to convert their interest in terms of basically being business people, basically business owners, by acquiring an already existing or basically a shell public company. And then of course, they start trading or carrying out business activities as a public company, So the advantage is, number one, it saves on costs and actually also saves on time involved actually in preparing like things like prospectus or maybe converting the company into becoming a public company. It has also a disadvantage. So sometimes you find that the people who are running the private company, they don't have the expertise or knowledge to run a public company. So it might be very difficult for them to be able to maybe manage or run a public company once they have converted into a public company or acquired the ownership in a public company. So sometimes there's lack of expertise in running a public company from those people who basically are used to running a private company. So that is actually a disadvantage of going for a reverse merger or basically restructuring through what we call reverse merger. So let me see if I can get another question here. So there's that question number 5A. Question number 5A. So Roman 1 and also Roman 2. Question number 5A. So Roman 1 and also Roman 2. It is from May 2019. It is from May 2019. It says Roman 1, define post-merger reorganization. Then Roman 2, discuss 4 types of post-merger reorganization. So define the term post-merger reorganization. Then Roman 2, discuss 4 types of post-merger reorganization, 4 types of post-merger reorganization. So what they mean by post-merger, just from the word post, it is after the merger, what actually happens. So how does the company reorganize itself? So remember when you are learning about this, when I talked about, for example, in this case, you find that the 2 companies have 2 different visions or missions. So they have to ensure basically they are working on it to ensure that maybe they have a similar or common vision. You find maybe the culture for the 2 companies is actually quite different. So these particular 2 companies have to ensure that they basically work on a common or similar culture. So you basically have to handle things to do with maybe the human resource. So are you going basically to lay off the employees? So how do you reorganize yourself basically to cope or maybe take advantage of what has actually happened in terms of the merger? So that is basically post or after the merger has actually happened. After the merger has actually happened. So I can see someone is asking which question is this? It is from, let me just reshare it. It is from May 2019. May 2019, question number 5A. Question number 5A. So Roman 1 says, define the term post-merger reorganization. Then Roman 2, discuss 4 types of post-merger reorganization. So discuss 4 types of post-merger reorganization. So May 2019, question number 5A. So you can just be able to define and say, just write it somewhere, define and say post-merger reorganization. What do we mean by it? You can just say it is post-merger reorganization. It is the rearrangement. It is the rearrangement. It is the rearrangements of the companies. It is the rearrangement of the company's activities. It is the rearrangement of the company's activities. It is the rearrangement of the company's activities. It is the rearrangement of the company's activities after a merger. It is the rearrangement of the company's activities after a merger. After a merger, so as to ensure the objectives. So as to ensure the objectives. So as to ensure the objectives planned. So as to ensure the objectives planned or set. So as to ensure the objectives planned or set are achieved. So as to ensure the objectives planned or set are achieved. So as to ensure the objectives planned or set are achieved. So as to ensure the objectives planned or set are achieved. The objectives planned or set are achieved. So how do you rearrange yourself, or how do you basically manage the functional areas of functional activities of the company, or all the activities of the company, so as to ensure you basically succeed in terms of the merger? So that's the rearrangements of the business activities. Then what are the types of post-merger reorganization? So you can mention number 1, just write number 1. Absorption absorption, 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 absorption. Then you can explain it briefly. So what is absorption, or what do we mean by it? It is when the acquiring company completely absorbs. It is when the acquiring company completely absorbs it is when the acquiring company completely absorbs the target, completely absorbs the target company, completely absorbs the target company, completely absorbs the target company. Completely absorbs the target company. Then number two, symbiosis. 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 You can simply write and say the merger only occurs in certain areas. The merger only occurs in certain areas to help meet the goals. The merger only occurs in certain areas to help meet the goals of the merger, or acquisition. So only specific areas are actually merged. So not all the departments or functions are actually merged. So symbiosis. So only the merger only occurs in certain areas to help meet the goals of the merger or acquisition. And then number three, you can write preservation. Number three, preservation. It is where the target company is left to self-govern. It is where the target company is left to self-govern its activities. It is left to self-govern its activities. It is left to self-govern its activities. It is where the target company is left to self-govern its activities, Then the next one, the last one you can be able to mention, it is known as holding. So we've said preservation. So the last one, holding. It is where the acquiring company It is where the acquiring company holds ownership. It is where the acquiring company holds ownership of the targets. It is where the acquiring company holds ownership of the targets. Holds ownership of the target company. It is where the acquiring company holds ownership of the target company, but they do not integrate. 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 So those are the types of post-merger integration. Those are the types of post-merger integration. Is it the same as post-merger integration? It is the same. So it is just the same. So maybe they could ask what is post-merger integration, or they could ask what is post-merger reorganization. So it's just the same. So the types of post-merger integration and the types of post-merger reorganization is just the same. So so there's this other question I want us to look at. Let's see. So it is question number 7B. Question number 7B. This one I want Mercy Simiyu. I want Mercy Simiyu to read for us. Mercy Simiyu, are you there? Are you able to see? Mercy Simiyu. So Mercy Simiyu can read for us that question number 7B.
Explain the distinguishing features of the following types of companies. Roman 1, companies limited by guarantee. Roman 2, private companies. Then Roman 3, public companies.
Yes. So Mercy has read for us very well. So that particular question is from this sitting. It's November 2020. Question number 7B. So November 2020, question number 7B. November 2020, question number 7B. So companies limited by guarantee, private companies, and public companies. So, so that question is from nature and classification of companies. So the first topic, it is from nature and classification of companies. The first topic, it is from nature and classification of companies. The first topic. Nature and classification of companies. So I think here we learned about, we defined a company. Looked at the characteristics of a company. We looked at the role in Solomon versus Solomon and Company Limited. We looked at lifting of the veil of incorporation. Then also we looked at the types of companies. Then we were also able to distinguish between a company and other forms of business. And other forms of business, other forms of business. And other forms of business. In this case, we are talking about partnership. So we're talking about sole proprietor, partnership, and cooperative societies. And cooperative societies. So that particular question is from types of companies. So if you can recall very well, so the teacher says that we can have classifications of companies under the Companies Act. So under the Companies Act, I hope you know how to switch. When you've shared the screen, there's a way you can switch the screens. So under the types of companies, if you can recall very well, so let me use here. If you can recall very well, so the teacher said under the Companies Act, if you look at the Companies Act of 2015, companies have been classified as limited companies. Number 2, unlimited companies. Number 3, private companies. And number 4, public companies. So under limited, there are 2. So you can have limited by guarantee, or you can have limited by shares. So limited by guarantee or limited by shares. So that is basically the classification of company, the types of companies under the Companies Act. So you can have either limited company or unlimited company or private company or public company, because they could test and ask, what are the types of companies under the Companies Act? So this is what you mentioned, you comfortably mentioned: limited companies, unlimited companies, private companies, and public companies. So therefore, in this case, when you talk about a limited company, if you can remember very well, is whereby I was actually emphasizing it is a type of a company where the liability of a member, is actually limited. It can either be limited by guarantee, or it can actually be limited by the number of shares held by this particular member of the company. What is a limited company? It is a type of a company where the liability of a member is actually limited. It is just the opposite of unlimited, whereby now the liability of a member is not limited. The liability of a member is not actually limited. In case of liquidation, the assets of that particular shareholder or member can actually be attached or be utilized to pay the liabilities of the company. We are saying this, a limited company, it is a type of a company where deni yako kwa hiyo kampuni iko na limit. Your liability as a member has a limit. It can go up to a particular extent. This extent is defined either by guarantee or by the number of shares you hold in the company or the amount outstanding on your shares. That is what we mean by saying your liability as a member is limited. Deni yako kwa hiyo kampuni iko na kiwango inafika. Either by the guarantee you've given, you'll be able to pay how much on the assets in case the company is liquidated, or the number of shares you hold in the company. For example, in this case, when you say it is actually limited by guarantee, the company is limited by guarantee. A company that is limited by guarantee, it is a type of a company whereby the liability of a member is limited up to the extent, and the extent is the amount he has guaranteed as to how much he will be able to contribute towards the assets in case the company is actually liquidated. So in this type of a company, on formation, in a company limited by guarantee, on formation, you actually agree as members of the company, or basically in this case, you actually agree that if the company is actually liquidated, you'll contribute a particular amount of money. You guarantee as to how much you can be able to contribute towards the assets in case the company is actually liquidated. So that is what we call a company that's limited by guarantee. For example, in this case, if you state that I'll bring in 10 million in case the company is liquidated, that is basically your liability. Hiyo ndio deni yako kwa hiyo kampuni ikianguka. Ikianguka watakuitisha hiyo 10 million. Ulisema utalete. So your liability as a member in that company is limited up to the guarantee or the amount you've assured you'll contribute towards the assets in case the company is actually liquidated. What of it if it is actually limited by shares? A company that is limited by shares, most obviously the first thing to know, the liability of a member is limited. Up to what extent? The number of shares you actually hold in the company or the amount outstanding on your shares. In this case, what we mean, for example, I was actually using this particular example, if you can remember very well, that if you have 10,000 shares in the company, you've only been able to pay for 8,000. They'll call upon you to pay for the 2,000 in case the company is actually liquidated. So that will be your liability in that particular company. You can see it has a limit. It goes to a particular extent. The extent is actually already defined either by guarantee or by the number of shares you hold in the company. If it is unlimited, it is where your liability as a member is not limited. If the company basically is liquidated, they can even go to the extent of even attaching your personal assets. In this case, they won't attach your personal assets because there is a limit. There is a limit. It can only go to up to a particular extent. But if it is actually unlimited, they can be able to attach your personal assets to be utilized to pay the liabilities of the company. That is what we mean by unlimited company. Private company. Private company, basically we define it by its characteristics. So a private company is a type of a company whereby the number of members is actually 1 up to 50. 1 up to 50. Also, what you need to be able to know about this particular company is that it cannot invite members of the public to subscribe for its shares. It cannot issue out a prospectus inviting members of the public to be able to apply or subscribe for its shares. What is a public company? So it is a type of a company whereby the membership, you define it by the membership also. The minimum number of members is 2. And there's usually no maximum limit. So it can go even to 1 trillion members. So the minimum number of members in a public company is 2. There's no maximum limit. Also, in this case, you need to be able to know that now in this case for a public company, it can actually be able to invite members of the public to apply or basically to subscribe for its shares. So that simply means that it can go out publicly, issuing out prospectus so that people can be able to buy its shares. And then the minimum number of directors is usually 2. Then there's what we call free transferability of shares. So shares can be freely transferred, freely in a public company. It's not the same case with a private company. So a private company, number of members 1 up to 50, cannot invite members of the public to apply for its shares. There is no free transferability of shares. Transfer of shares is actually restricted. A public company, minimum number of members is 2. There is no maximum limits. There is free transferability of shares. That is characteristic number 2. Number 3, minimum number of directors is actually 2. And the shares can actually be freely transferred. So it can also be able to invite members of the public to apply or basically acquire its shares. For a private company, the minimum number of directors is usually 1. So it can have at least one director. It can have at least one director. So that is basically the types of companies under the Companies Act, But remember we said there are other classifications. So not only under the Companies Act, you can find companies also being classified differently. So for example, in this case, we looked at we looked at corporation sole. So these are other classifications, corporation sole, other classifications. Corporation aggregate. We learned about holding company and subsidiary. We learned about statutory corporations. Statutory corporations, learned about foreign companies. We also learned about chartered companies. We also learned about chartered companies. We also learned about chartered companies. Chartered companies, chartered companies, chartered companies. So corporation sole, you can remember very well, like we said that a corporation sole, it is a type of a corporation whereby it is a form of independent office that is normally held by a sole person. That is normally held by a sole person, and there is what we call succession in the office. So it is a kind of an independent office that is normally held by a sole person, and there is succession in the office. So the example he gave is, for example, the office of the president, or maybe the office of the bishop. So the office of the president basically will be held by a sole person, so it cannot be held by two persons. So only one person can actually be able to hold that particular office, or that particular office. So even though maybe here in Kenya there was a time they were saying we have the real president, we have the real president, and of course also we have the people's president. So, but there's no way basically they can actually be two, even though it was being said like that here. We have the real president and we have the people's president. So I don't know what people are meant by that, but that office can only be held by a sole person. So it is a form of, the way that office is basically organized, it is like a form of corporation. So you can be able to see that when this president of ours basically will end his term, he won't go home with the state house. So that is an asset basically held by that office. So he won't go away with basically the government vehicles. Those are basically assets held by the office. So the one who will be coming in, whom we don't know at this particular point, only God knows, will basically take over those particular assets, or maybe be able to utilize them. So you can be able to see the way it operates. It is like some form of corporation because it can be able to have assets. It is an independent office. So no one basically is inclined to it. That's when he basically his term expires, he goes away with the office. The office still remains. Another person basically assumes the office. So it is like a form of a corporation. So it is actually an independent office that is usually held by a sole person, and there is what we call succession in the office. So an example: office of the bishop, office of the president, office of the bishop, office of the president. Corporation aggregates, it is any corporation or company whose ownership or minimum number of members in terms of ownership is actually 2. So any type of a company that's whose aggregate number of members, basically ownership of the number of members, is actually at least 2, it will be known as a corporation aggregate. So that is what we mean by a corporation aggregate. So statutory corporations. So this one, I think you know about it. You know about it. You've been singing about it, I think, of late in financial reporting. You've been singing about it. Those who are basically doing financial reporting for the first time. Of late, you've been singing more about it in financial reporting. Holding companies and subsidiaries. Holding companies and subsidiaries. So I don't have to elaborate more about them. You can be able to define them. So a holding company is simply a company that has ownership or has acquired ownership or a stake in another company. So it will be known as a holding company. So that other company, now it can be known as a subsidiary. If basically the ownership is between 50% plus up to 100, 50% plus up to 100. So it will actually be known as a subsidiary. Then statutory corporations, this one is the one I have a key interest in. Statutory corporations, so this one, you know about it. So some people call them parastatals. You say that me, I just want to work with a parastatal. So if I get a job in a parastatal, I would have resolved all my aspirations in terms of work or maybe my career. So I just want to work in a parastatal. So there you don't work on Friday. You just go relax up to 1, then you go home. After lunch, you've gone home. It's not like in these other sectors where you have to work up to 5, weekend you are there. Here, by Friday, 1 p.m. you're done with the work. So those are the kind of corporations we call statutory corporations. So what are they? So they are usually basically formed or they come into existence. I want you to basically to be able to understand the characteristics about this one. So they come into existence. Number one characteristic, they come into existence through an act of parliament. And the most predominant examples we can be able to give is, let's say, for example, the Kenya Ports Authority, Kenya Broadcasting Corporation, Kenya Railways Authority, Kenya Pipeline Corporation. So those ones basically are simply statutory corporations that have come into existence through an act of parliament. So sheria inapitishwa kwa parliament kwamba zikuwe formed. So they don't just come into existence, or they don't come into existence like any other normal company or corporation. So their existence is actually happening because there was an act of parliament that has actually approved their formation. So they come into existence through an act of parliament. That is number one. Number two, the act of parliament will set out the management structure of the corporation. For example, they'll clearly state there'll be a board that will be basically be led by the chairman. There'll be a chief executive. So that act of parliament will set out the management structure of the corporation. So number two, the act of parliament sets out the management structure of a statutory corporation. Number three, they are majorly formed to provide essential services to the citizens. So their primary objective is to provide essential services to the citizens. That is number three. Number four, profit making is not a major objective for them. It's just a secondary objective. We've already said their primary objective is to provide essential services to the citizens. Number four, profit making for them is just a secondary objective. Is not their major objective that they make profits, because they are usually funded by the treasury. Even that one, you can be able to capture it as number five characteristic. They are normally funded by the treasury. This simply means each and every financial year, when they are setting out the budget, they are usually allocated some amount from the treasury or from the government to run their activities, Number six, in case they make any profit, the profits will basically be remitted to the treasury because it is the one that actually basically funds them. The last one, they don't undergo the normal liquidation process. Their life basically comes to an end when the act of parliament that formed them is actually revoked or basically superseded by another act of parliament. So these ones, they don't undergo the normal liquidation process, the one that I taught you in class. For them, so long as the act of parliament, ile sheria ambayo ili create hiyo corporation bado iko, hiyo kampuni mjue tu bado iko, the life has not come to an end. Only when that act of parliament is revoked or basically it is superseded by another act of parliament is when the life of the corporation will be seen to have come to an end. So those are the characteristics of a statutory corporation. So maybe they could ask in the exam, don't say that is Greek, I've never heard about it. Hata teacher could mention hii, hata kugusia. Imagine your teacher mwenye alitufunza hata kugusia hiyo, so hata hiyo hatujui. So I've mentioned it, I've basically clearly explained the characteristics. You've said it is that one that AB wishes to work in, ambayo wanatoka kazini one year parastatal, that one parastatal, I just want to work there. So that's basically where AB wants to work. So if you remember that, then the teacher mentioned the characteristics that they are usually formed through an act of parliament. So the act of parliament sets out the management structure. Their primary objective is to provide essential services to the citizens. Profit making for them is just a secondary objective. It's just a secondary objective. They are usually funded by the treasury. If they make any profits, the profits are normally remitted back to the treasury. They don't undergo the normal liquidation process. Their life can only come to an end if the act of parliament that actually formed them is actually superseded by another act of parliament, or the act of parliament is actually revoked or cancelled out. So that is what we mean by a statutory corporation. So foreign companies, I think we've learned about them under companies incorporated outside Kenya. So we've learned about them under companies incorporated outside Kenya. It is simply a company that initially was not actually registered or incorporated in Kenya, but of course they have sought base, or they have sought to carry out business activities in Kenya. So in Kenya, they'll be recognized as being foreign companies. Initially, they were not incorporated or registered in Kenya. They were registered outside the country, but they have sought base, or they have sought to carry out business activities in Kenya. In Kenya now, they will be recognized as being foreign companies. So mostly they are usually the international companies you actually see around. Chartered companies. So these are simply companies that come into existence through an issue of a charter. So the best examples you can be able to give are the private universities. So the charter is normally given, a charter is like an authority that has been given to provide a particular service or a certain service. So here in Kenya, it is the president who gives out the charter. So that charter to a private university. So it becomes a chartered company. So the way that university actually operates, it is like some form of corporation or some form of company, because in this case, you find that Caroline will basically be a student there at USU, at USIU, at USU, USIU. So Caroline basically will finish her studies, go find that other students will just come, so that vice chancellor is there, will be there, finish her term, she goes, the university is just still there. So long as the charter is still in existence, it operates like some form of corporation. That's why it is basically recognized as being like some form of a company. It is known as a chartered company. So it is simply a company or corporation that is basically formed through an issue of a charter. What is a charter? It is simply an authority given to a body to maybe provide a particular service, So the person who can be able to give out the charter is actually an authorized person under the law. For example, in Kenya, it is the president who can actually be able to give out or issue a charter. Examples of these particular chartered companies we are giving is basically private universities. So that is basically what we learned about in terms of the types of companies, So I think there we've been able to knock the examiner. So he can't trick us. He can't give us a trick in terms of the types of companies, So there's another important bit which I want us to be able to be very keen under this particular topic. So there's that bit of distinction between a company and other forms of business. So the question will be very simple. Brian Order. That distinguish between a sole proprietor and a company. Just like that, the question will be very simple. Or alternatively, it could be distinguish between a partnership and a company. Or now they confuse you. They want to confuse you. They tell you distinguish between a partnership and a private company. You start asking yourself, a private company. So they're just simply asking the difference between a partnership and a company. But now they have indicated their private company to confuse you. So probably basically the distinction will just almost be like similar between a partnership and any type of a company. So, and of course, here the trick is you just need to know the characteristics of each and every form of business. For example, when you talk about a partnership, do you know what is a partnership? Can you be able to mention like 6 characteristics about a partnership? Are you able? If you are not actually able at that particular point, then just know that at that particular point, just know that it will be very difficult for you to even write even a single point. You must need to be able to know and remember what is a partnership. Number 1, membership of a partnership or ownership of a partnership 2 up to 20 persons. If you know that one, you are at an advantage because you'll simply compare that with the side of a company. You also try to remember in a partnership what actually happens. In a partnership, they contribute capital by themselves as partners. So that is basically a characteristic. So you try to compare it to the side of the company. You also try to remember, you scratch your head, and also actually remember that in a partnership, what actually happens, they manage the partnership business by themselves. So they manage the partnership business by themselves. So they can be able to share duties. So they say this one will handle finances, this one will handle operations. So they manage the business by themselves. You compare it to the side of a company. So that side of the company, the teacher has been singing that in a company, they are directors. They are appointed by shareholders. So shareholders are owners of the company. They don't run the company by themselves. They appoint other parties to be able to run the company. But in a partnership, they can be able to share the duties and manage the business by themselves. You also scratch your head, you remember in taxation. We learned in taxation that when you are calculating the tax liability of a partnership, you go there, you calculate the business profit, then you now share the profit among the partners. Then when you tax them individually. So you remember also in taxation, you learned that in a company, you basically simply do corporation tax on the business profits or basically on the company profits. So you now be able to say that in a partnership, tax liability falls on the owners or the partners themselves. In a company, it falls on the company itself through what we call corporation tax. I hope you are getting my point. If you're able to mention the characteristics of each and every form of business, then you just compare with the other side of the company. There must be a difference. It should be there. So I think maybe you'll be able to pick up from this particular point of distinction between a company and the other forms of business so that you can be able to understand what I mean by that. In our next class, then probably we'll be able to look at another topic and see how far we can actually be able to go with the revision. So otherwise, I wish you all a good night. I think we are remaining with how many classes are day 2? I don't know, there are 2. Let me see the calendar here. But we can be able to do something. So we are remaining with that class of when is this? It's 27th. And because I'm meant to understand the last class is actually on 31st. I don't know when is your paper. When is your paper? That paper for company law. When is your paper for company law? Have you gotten the timetable or not yet? It's on 4th. The paper is on 4th. Huh? So the paper is actually on 4th. So I can see it is actually on Monday. It is on Monday. Okay. So the paper is actually on 4th. So we can do this. We can, although here the arrangements are that we have the last class on 31st. If you guys are actually okay, we can do that class of 3rd, that Sunday. We can do a final class there. We can probably do a final class there. So we do this particular class of Sunday, this coming Sunday. We do again on Tuesday. Then we also do again on 3rd. So we're remaining like probably like maybe 3 classes. We could have done more, but I know there are those who are basically preparing for other subjects. So we can't do we can't do so much. But I think maybe you can only spare for an extra class, maybe like on 3rd of Sunday, just before your paper. Then I think we'll be done with the revision. Otherwise, keep on revising. So there are some model papers I shared there, some Q&A I shared on shares, debt capital, and share capital. Though we'll still go through those particular topics in class. We'll still go through them still here in class in the revision because they are very important. Don't forget to revise properly that topic of formation of companies. It is a major topic. It is the most tested area in company law. Formation of companies. It is the most tested area in company law. So you must be able to understand it properly, although we'll still go through it here in class, probably after maybe nature and classification of companies. Then, so there are those things I'm posting on the group. So just be reading them. So if you're in a matatu, if you are going for that lunch break, you know, what I know with part-timers, you'll never get time to revise. So if you are waiting that you get that leave to start revising, so it is normally very difficult. Probably that leave might bounce. You won't get it. You'll only be given 2 days. So there's usually no time. So if, for example, if something is posted, for example, on the group like that, it is very easy for you to be able to access. So if you are on a matatu, if basically you are maybe going out for lunch, you can be able just to open it and maybe just have a look at it. It's good to have a look at it, just have a look at it, what has been posted here. Yani what I mean, unakuwa rada, uko rada kabisa, uko rada as to what is happening in terms of maybe what can actually be tested. So, so I think that is okay. So if you guys are okay with that third class, that's that Sunday before the exam, we can be able to do it. So otherwise, I wish you all a good night. And the exam will actually be very easy. So if you prepare very well, the exam will actually be very easy. So I normally advise my students that don't abscond classes, just come to the class. Even if you are very tired, just come to the class and start listening to the teacher, what the teacher is saying. You'll be able to gather a lot. You'll be able to gather a lot. So those who have basically maintained that discipline, so I can assure you the paper will be very easy. The paper will actually be very easy. It won't actually be very difficult. And you know, for a paper like company law, if you are prepared so well, basically you realize that you'll do the paper very fast. And for sure, this particular paper, students normally don't take 3 hours in the exam room. After 1 hour, you'll see students walking out, they have finished the paper. So if you are prepared so well, so this particular paper will actually be very, very easy. So you don't have to panic. You have to be very confident when you're walking into the exam room. And how can you be confident? By simply listening to the teacher, following the instructions. And then when you walk into that particular exam room, sasa utakuwa umeomba vizuri, sasa umeingia exam room. So confidently, you'll be able to realize that the paper is actually very easy. It is actually a very simple paper. It is normally very difficult. It is not like that other paper known as financial reporting. So that one, probably you'll see people leaving the exam room, so they'll just be carrying up their hands. Iyo tumeachia Mungu, iyo tumeachia Mungu. So this particular paper is not the one to say like that, because I'm telling you, after 1 hour, you'll see students walking out, they have finished the paper. So basically, if you've been following what the teacher has been saying in the class, you might be, basically, most obviously, you'll be among those ones who will basically finish the paper very fast. So there are 7 questions. You just choose your best 5, and basically you'll actually pass. You'll actually pass. Most of the students I've actually taught in this particular paper, they have never had a lot of difficulties in terms of handling the past paper questions or basically doing the exam. So if you've been following the instructions in the class, you've been attending the classes, basically I can assure you the paper won't actually be very, very difficult. So we'll meet on Sunday. So let's see how far we can be able to cover with the other topics, and we'll see what will actually happen. So I wish you all a good night. We'll meet next time.